Welcome to Securing Your Brand with SecureMark Legal. On this podcast, we break down the legal side of branding and protecting your business without the legalese. From trademark, copyright, and contracting tips to real-world case studies, we're here to help you safeguard your business, your brand, and reputation. We are here to help entrepreneurs, creatives, and business owners protect what they've built through smart, strategic IP solutions.
Hello, I am Holly McFall, a trademark attorney. Welcome back to Securing Your Brand with SecureMark Legal, where we make legal stuff, especially trademarks, way less scary and way more actionable.
And I'm Lisa Jeda. We work with business owners, creators, entrepreneurs across the country to help them protect their names, their brands, their intellectual property, that which defines their business.
Today, we're talking about what you can actually trademark. We'll break down what qualifies for protection, what does not, and some of the most common reasons trademark applications get rejected.
And I'm Lisa Mosbey, here to ask, can I actually trademark this or that type of questions? What kinds of things can actually be trademarked, ladies?
Really, anything that identifies your brand. A trademark protects your brand identifiers, that which your customers connect with, and they relate to and recognize for your goods or services. Whether that's your business name, your product name, your logos, your slogans. Really, the key requirement is that it identifies a source of goods or services. It's how your customers know you.
And the mark must be used in commerce, meaning it has to be tied to actual business activity. It has to function as a brand, not just a word or a slogan. The stronger and more distinctive the mark, the easier it is to protect it.
It's not just the names and your logo or your slogan. It's things that your clients recognize. Think of Play-Doh. You know, when you open up a Play-Doh and you smell that smell, you know that smell. From me saying it, you know what I'm talking about. That's trademarked. Zippo tried to trademark that sound of when they open up a lighter. So sounds can also be trademarked, not just the things that we recognize. We know that colors can be trademarked. Think about that, robin's egg blue box. You know what company I'm talking about. Or that cell phone company that has the bright pink. So anything that identifies your brand can be trademarked.
And what are some of the things that people try to trademark that are usually not allowed?
Okay, so first, generic terms cannot be trademarked. So, for example, calling a coffee shop coffee or Atlanta's best barbecue, that would be geographically generic. So, common phrases or widely used sayings are generally not protectable. Another one is profanity. That may be difficult or refused depending on context. Titles of single books or single creative works are also not trademarkable unless they're become part of a series.
So if you're using a generic term for your part of your brand name, so it's not like your entire brand name. Let's use our brand name, SecureMark Legal. Yes, we're trademarked, but we don't have exclusive use to the word legal. I can't stop other lawyers from using the word legal in their brand description, but the mark as a whole is not generic, just that word. So the entire mark is trademarked. SecureMark Legal is trademarked. The USPTO looks at whether the term, if it is generic, but it's not distinctive for what you're using. It's not like, oh, I automatically put that together. Think of Apple for computers, not for hard apple cider. And so it's really important that when you're choosing a brand name, you're choosing a logo or slogan, it really is distinct. It's unique to you. And that's really what's most important.
And what is the difference between a word mark and a logo, and which one should someone trademark first?
Think about the word mark is protecting the name itself, whether it's your brand name or your product's name. It's protecting the name itself, not how it looks. So not the fancy script, just the actual wording that you want to protect. And that offers you the broadest protection. A design mark protects stylized items, graphical items, your logos, your name if it's written in a stylized font. That stylized font is specific to you. Think Coca-Cola font. And what you should protect first, really, you should start protecting your brand name. That's what's recognizable. That's what your clients are going to know you by. So you want to make sure your clientele and you protect the name that your clientele recognizes. And that's where we suggest for our entrepreneurs to start first.
Yeah, and another reason for that is that logos can change over time, but the name often stays the same. Even subtle changes in the logo, you may play around with the colors or, want to change the design in some minor little way. Any small change becomes a different trademark. So the logos tend to have a shorter shelf life than the word brand names. So that many businesses start with a word mark because it covers more use cases. In some situations, both may be appropriate depending on the brand strategy and, of course, budget. A lot of times people come to us with a limited amount of money, of course, especially when they're first starting out. And we generally, in that instance, will recommend starting with the word mark first and then exploring filing for trademark protection on the logo a little bit further down the line. So if you're just starting out and do not want to have the name trademarked first, another tip is that we sometimes will recommend filing the logo application with just the graphical element alone, not with the name included. So that's kind of the flip side of what we were just talking about with the doing the brand name first. So in this instance, that sort of strategy is that if you're not sure that this is the exact name you want to stick with, or if we found possibly other conflicting names when we did our comprehensive search, and we're not completely sure if it'll go through with the USPTO, we may file the logo application without that name at all. And that way you have protection on the graphical elements of your logo, the things that become recognizable to your audience and your customer base without committing the business yet to that exact brand name.
And how should business owners think about what to trademark first or how to approach filing?
So we focus on the core. What is the core brand name or names of your products? That's what we want to trademark first. That's what we want to make sure the public, the consumer, identifies and recognizes. But like Holly said, there are times when that logo is more important. So it's really make sure that you're looking at your distinct elements. You want to make sure that that brand name, the product name, is just that distinct, unique to you and your company. When designing your brand name, you want to consider how it's going to look across the market. You want to look at your logo, how it's going to look across the market. These are considerations because remember, we're building the foundation of your business here, especially for a lot of entrepreneurs. So you want to make sure that you're considering every aspect of it, not just the sound, but also the appearance. How does it look on social media? How does it look on advertisement? How does it look on a business card? How does it look on the product and the packaging? Those are considerations, not just for the name itself, which is important, but also the logo, the stylized. You want to make sure all that marketing material, the social media material, even that you can own the domain name. So when you're considering a name, these are all factors that need to be considered.
Yeah, and so a big way in which we figure out all of these little details and what's best to file for and not file for comes from that comprehensive trademark search that we run. You know what you need to do to make your business distinctive, or what, maybe a certain color is already being used in your industry and you want to avoid that and go in a different direction. You have to look out there and see everything that's out there in order to make those calls. Filing the right mark at the right time helps avoid unnecessary costs. So again, doing the work up front prevents or at least diminishes the likelihood of us finding out these issues later on down the line after your application is filed, or even later once the trademark examiner at the USPTO gets a hold of it and does their review. We want to know everything up front, and that makes things less costly for you in the long run. A strong trademark strategy starts before filing, not after. So think of it as a registered trademark is brand insurance. Working with an attorney early on can help identify issues before they become problems.
Okay, ladies, we've come up with a great name and you've filed your trademark application. Now what? What are the most common reasons a trademark application gets rejected by the USPTO?
So an examining attorney is assigned to each trademark application. The examiner can approve an application for publication, which is the next step towards registration, or they can file an office action. An office action is basically the reasoning for refusing a registration. The number one reason is confusingly similar to an existing trademark. This is why, again, the comprehensive search is most important. Another reason for refusals is ornamental use. That means using the trademark as decoration rather than as a brand identifier. So a good example of that is if you're selling a t-shirt and you have your brand name in real big letters on the front of the t-shirt, that generally signals more of a phrase or something that's more decorative on the t-shirt versus telling the world who made that t-shirt. So when Hanes makes a t-shirt, for example, you usually don't see Hanes written big across the front of the t-shirt, right? You see it on the little hang tag on the back of the t-shirt, and that's what tells everyone that Hanes made that t-shirt. It's not some, silly little saying that we're trying to say on the t-shirt, Hanes.
It's the product identifier. It's identifying the product.
So not functioning as a trademark is sort of similar. It's not clearly identifying the source of goods or services. We also see improper specimen refusal from pro se or trademark filers who are not attorneys. So the specimen is the example of use that you attach to your trademark application, showing the trademark office that you're actually using this brand in commerce. You're actually using it to sell a product or a service. So there are specific guidelines that have to be followed in those specimens, sometimes getting kind of technical about what has to be included in those specimens and what will not be good enough. So that is a common source of refusal in office actions that we see a lot.
We also see a lot of incorrect classifications or descriptions of the goods or service. It's really important that you are registering in the proper class, but you're also registering with the proper classification, the proper description in that classification. One of the things I think we see is like physical fitness equipment, and then you see like physical fitness storage racks. And the storage racks or the containers for physical fitness equipment is different class, it's class 20, than the physical fitness equipment, which is class 28. And we've seen that get messed up. We've seen people that have a podcast or they have a non-downloadable educational course register, in class 41 instead of class 9 or things along those lines. So it's really important that you make sure that your description is proper for that class and that you're in the right class to start with. Something that, we'll see is surnames. Your last name, your surname can be trademarked. It has hurdles that it has to go through depending upon the distinctiveness, depending upon how long it's been used in the market. We've seen that come through, and we've seen a lot of questions lately about supplemental registry and what it means to be put on the supplemental registry through an office action and not on the principal registry. A lot of these things, though, that Holly's talking about, that I'm talking about, can be really avoided by having some planning up front, having and discussing your trademark application, your brand protection with an attorney prior to filing the application.
So, ladies, before we wrap up, what are a few key takeaways for business owners thinking about trademarks? Let's really just shrink this down and give them a concise list.
Okay, so choose a name that is distinctive, not generic. Understand the difference between word marks and logos and when to use them, which one you want to protect when. Have a comprehensive search run before you file your trademark application, and get guidance before filing to reduce risk.
Taking the time early on can make a really big difference. It can make a difference in how strong and enforceable your trademark is later. It can also solve some, costly mistakes from happening, and look at them now instead of before we can solve or resolve the issues.
Wonderful. And well said. Very succinct. Thank you so much for joining us on Securing Your Brand with SecureMark Legal.
If you're considering filing a trademark, whether you've been in business for years or just starting out, you want to make sure that you can fully own that brand. The only way to fully own a brand is through registering a federal trademark.
We have resources on our website to help you choose and design a distinct brand name and to schedule a consultation with us. www.securemarklegal.com.
Thank you for joining us. We look forward to speaking with you and learning about your business, helping you protect your brand.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.